Ownership on paper doesn't necessarily mean that there is no community interest or you don't have any interest. The source of the money used to buy the asset is really important. If a property was purchased during the marriage, the presumption is community. Then the court looks at any agreements, written agreements, and to determine whether there's an ownership or not. So just because you're not on title doesn't mean you don't have ownership interest. You do not have to move out of the house during the process of the divorce. Both parties can reside in the family residence while they're going through the divorce process. At the conclusion of the case, the court will either sell the property or award the property to one of the parties. At that point, obviously you would have to move out. However, if there's allegations of domestic violence during the pendency of the case, the court could give exclusive control of the family residence to one person. California is a no-fault state. In order to get a divorce, you do not have to prove in California that the other person did anything wrong. However, acts of domestic violence can have an effect on how support is allocated and how custody is determined.